For over a decade, USCIS has applied a two-step analysis to EB-1A petitions, including what's known as the final merits determination. But in February of 2026, a federal court in Nebraska ruled that the way USCIS adopted that framework was improper, and the district court vacated USCIS's denial of the EB-1A petition and remanded the case with instructions to approve. The ruling directly challenges USCIS's long-standing use of the so-called final merits determination, which is the second step of the Kazarian framework that has increasingly been used to deny otherwise strong EB-1A cases. Now, naturally, many applicants are asking, has the EB-1A standard changed? But before jumping to conclusions, it's important to understand exactly what the court decided, and just as importantly, what it did not decide. In this video, I'll break down how the EB-1A two-step framework works, what the Nebraska court actually ruled, why this decision matters, and what it means strategically if you're filing or were previously denied. To understand the significance of the case, we need to revisit how EB-1A petitions are evaluated. USCIS uses what is commonly called a two-step analysis. The first step is the regulatory criteria. The applicant must meet at least 3 out of the 10 regulatory criteria, such as major awards, published material about the applicant, original contributions of major significance, judging the works of others, high salary, membership in associations requiring outstanding achievement. This step is largely evidentiary and checklist driven. Then comes step 2, the final merits determination. Even if the applicant meets 3 criteria, USCIS then conducts a broader evaluation. Does the totality of the evidence demonstrate sustained national or international acclaim? Does the record truly establish extraordinary ability? In recent years, many strong applicants have met the criteria but were denied at the final merits stage. It is what happened at the federal case here, and that's where most frustration happens. And it's what happened in this case as well. The applicant met the criteria. USCIS denied the case at the final merit stage, asserting that the petitioner lacks sustained national or international acclaim. The applicant filed a lawsuit in federal court. The court examined how USCIS adopted the two-step framework, and the key issue was procedural. The court found that USCIS improperly adopted the two-step final merits framework without going through required rulemaking procedures under administrative law. The case was sent back to USCIS for re-adjudication, and now here's the critical clarification. The court did not say that all final merits denials are invalid nationwide. It did not eliminate final merits review. It ruled on how the agency adopted the framework, not whether extraordinary ability must still be proven. That distinction is extremely important moving forward. This decision focuses on process, not on lowering the EB-1A standard. But process matters in administrative law. If other courts adopt similar reasoning, it could influence how final merits determinations are applied or structured in the future. However, extraordinary ability is still required by statute. The burden of proof has not disappeared. What may evolve is how USCIS articulates and applies that framework. This is why the reaction should be cautious optimism and not celebration. And let's be very clear about what this ruling does not mean. It does not mean that EB-1A is suddenly easier. It does not mean that all prior denials will be reversed, or final merits review disappears overnight, or that you should immediately refile without analysis. Federal district court decisions typically apply to the specific case unless adopted more broadly. Immigration law changes gradually and not instantly. If your EB-1A was denied at the final merit stage and you're wondering whether this decision affects your options, you can request a free case evaluation using the link below. The answer really just depends heavily on timing, your case, and the jurisdiction. Now, of course, there's several possibilities that could exist of what happens next. USCIS could appeal the decision, narrow its application, continue applying the Kazarian two-step framework in other jurisdictions, adjust internal policy guidance. There's also ongoing litigation in other jurisdictions challenging similar issues. So we're in a period of legal uncertainty, and uncertainty requires strategic caution. So let's break this into categories. If you're denied recently, review the denial language carefully. Was the denial purely based on the final merits? Was there also a criteria dispute? Think about timing because timing matters. If you were denied years ago, litigation may be an option in some cases, but statute of limitations and procedural posture are critical. If you're planning to file, strong preparation still matters. Meeting 3 criteria is sometimes not enough. Your narrative must clearly demonstrate sustained acclaim and top-tier impact. Even if litigation reshapes the final merits framework, strong evidence and strategic presentation remains critical for every EB-1A case. Court decisions can influence structure, but they do not replace substance. Federal court decisions can shape immigration law over time, but they rarely create overnight changes. For now, this Nebraska ruling applies to one case. Whether it influences broader EB-1A adjudications will depend on how USCIS responds and how other courts interpret the issue. If you've been denied on the final merits or you're preparing an EB-1A petition, the most important thing remains the same: building a strong, well-documented case that clearly demonstrates extraordinary ability under the law. If you'd like to understand how the development may affect your specific situation, you can request a free case evaluation using the link right below in the description. And if you're pursuing an EB-1A, I recommend watching my next video. Understanding how USCIS evaluates extraordinary ability is still critical, regardless of how this litigation evolves.